Lordship, there is just one item which has been mentioned. Lordship may not like to take up that matter. Item 14, Lordship.
Okay. Put it before any other bench without one of us.
Mention
Item 15 to SLB as a hearing.
15 to mention हमको दो.
Item 15, madam. Against
The 2017 matter.
2017, madam, my lord. Against the order, this is a red judicata matter, my lord, and SLP has been referred before the Honorable Supreme Court, my lord. This was supposed to be listed immediately after the vacation. Unfortunately, this was not listed, my lord. Admitted, my lord, delay condoned, my lord.
In this matter,
In this matter, my lord, we have put into challenge the second notice, my lord, by a common judgment of this Honorable Court, my lord. That was challenged in 2018, my lord. In our matter, this has been tagged with the other matter as well, my lord. Number that I have given, my lord, it is there in the order sheet.
earlier Amina
Okay.
Khatun's order was silenced.
Amina Khatun's order was.
Both sides are represented on the prayer made by learned counsel for the petitioner.
Yes, Tapadam.
Matter is adjourned today. List after 2 weeks.
Four.
4.
weeks.
You can make it 4 weeks.
I'm deeply obliged.
May I, Your Lordship? It is with respect to item number 29. Our only anxiety is the matter might not reach. So it may be fixed on at 2 o'clock. And the person is in detention.
Okay. At 2.
Much obliged.
There was a listing of an IAO just for a modification. Can it be listed on tomorrow, Your Lordship, of earlier order only?
Friday.
No, Friday is already.
Oh, Friday is the holiday. The next working day.
My lord, I beg to mention item 30. May kindly be passed over for the day as my senior counsel is out of station due to some health issue.
Item, ma'am.
30.
30.
Okay. Both sides are represented. List after 2 weeks as paid for by learned counsel for the petitioner.
Daily list item 1 for motion.
Status report, madam.
Well, I have received this status report, my lord, from the SP. The person could not be recovered, but the investigation is going on. 3 persons they have detained, my lord. Their statements have been recorded, and the SP is supervising the matter, my lord. Supervisory note is also there. Para 6 में kindly see, my lord. This. Status report. এই তিনিটা মানে মোশাৰফ আলালুদ্দিন জিয়া আহমেদ ইহঁতক হেৰি কৰিছে এৰেষ্ট কৰিছে কোৱা কৈছে মোশাৰফ আলী হালালুদ্দিন জিয়া হালালুদ্দিন জিয়া আহমেদ But that I have not seen. Lord. That has to be done. Hmm. Yes. Lordship. Lordship. But the SP is supervising the matter, and these are being these steps are being taken by the IO. But I prefer giving some time. Let them complete the exact investigation, and we'll come up with the report.
This is the general investigation which is being carried on. Standard protocols.
But
So
the three
fact remains that the person has not been
yes, it
recovered or traced out.
Lordship.
So there has to be some more specific action taken.
But
It is not available in the report. It's a routine investigation that you do. Collect CCTV,
in fact,
call detail report. These are the
these are part of the investigation. But the three persons, they have also apprehended, and ultimately the statements were recorded, but nothing has come out. Newspaper and television circulation, that was not done, but now the SP has advised.
Things which have which has come to our office.
Malad.
And it's paragraph 7 last page.
Yes,
Second last page.
Lordship.
And paragraph 3 and 4 last same page.
Lordship. Lordship is indicating the action suggested by to the IO.
yes.
Action suggested. Lordship.
You effort here to be CDR already collected. That means no effort has been taken to collect the CDR.
CDR Malad has been collected, serial number 9 Malad. The action taken by the IO. Kindly see Malad, action taken by the IO, serial number 9.
After that, what has happened? This collection. This might be correlated to something.
But in connection with that, Malad, the persons were apprehended. 3 persons were taken by the police.
On this basis.
Yes, Malad. Paragraph 6, Malad. Paragraph 6 of the comment, Malad. At first page, Malad. The investigation officer of the case, SI Dipankar Shetty, visited the place of occurrence, drawn a sketch map. The IO sent a WT message to all so and so. The IO collected CDR of the victim and conducted IMEI search, but no any clue. During course of investigation, IO arrested suspected persons, namely so and so. and forwarded them to judicial custody.
How much time you are taking?
Lakshmi, give us let it come after 4 weeks. Some vacations are also there. The up-to-date position will apply. In the meantime, the publications in newspaper and televisions, including all that has to be done.
Mr. Singh, give them some time.
Well, 4 weeks too much, my lord.
Because we can't have
My lord.
prior to that.
At least, my lord, it come before Puja vacation, my lord.
No, sure.
Definitely.
Yes.
Of course. Of course.
Let it be in the last week of September.
20 September.
20. Gotcha.
But Mr. A.R. Siddiq, learned counsel for the petitioner.
Oh, not episode DD. Episode DD. Get the episode DD. Episode DD. Episode DD.
Mr. D. Nath, Leonard, senior government advocate, has produced a copy of letter dated 28/2024 by the Superintendent of Police, Nagaon, along with supervision note. This supervisory note will return it to you. It leads to premature disclosure of many things.
Alright.
Unwanted people may
Gotcha.
come to know about it.
Gotcha.
Those comments. And I submitted that he also has a copy of the supervisory note of Kohiat PS case number 495 of 2023. It shows the progress of the investigation done so far. The copy of the said letter dated 28/2024 is retained on record. However, the supervision note is perused and returned. Next one. On a query of the court, the learned senior government advocate has submitted that he would inquire as to whether the photograph of the victim has been circulated for wide publication in newspaper and television, and shall inform the court on the next date of listing. First off, if they said process has not been done so far, state may initiate the process of publication of the photograph of the missing person, not victim, missing person, in newspaper and television as per the standard protocol. Next on the prayer made by the senior government advocate. We grant further time to the next date of listing for producing the status of the updated updated status of the investigation done. Next paragraph, list on 209/2024. Supervision note here.
I'll take that.
Last thing interface.
I'll let it up.
Item 2.
Yes, Mr. Kotogi.
Yes, ma'am. In a pending execution proceeding under the review act, this petitioner, my lord, the warrant of arrest was issued, my lord. And it was, next date was, it was issued on, next date was fixed on 29/6/2024, my lord. On that day, my lord, the report has been submitted, my lord, that it could not be executed, my lord. And at about 3:30 PM, my lord, they have submitted report, and so-called reply was also submitted, by. But on the date day itself, at 3:45 PM, my lord, he was taken into custody, my lord. And he was kept in the police station for more than 24 hours. On 1st of July, my lord, the relatives, my lord, they requested him to produce him, my lord, but they misbehaved with their relatives, my lord. And subsequently, after 24, more than 36 hours, they produced me. And in fact, the warrant, there was no face warrant also on that day, my lord.
No, because you see, 29th, if you see, he was arrested.
Yes,
29/6 was a Saturday,
Saturday, yeah.
correct? 30 is a Sunday.
Sunday, but they could have produced before a Alakami statement.
We don't know because from that day onwards, there is a puja vacation.
No, the Alakami is always stays in the Sunday, my lord, because there is a sub-division court in Kaliabad. That apart, my lord, when the relatives went there, my lord, because
He's still in custody.
no, he's been
Released.
released. Now he's released, my lord.
So then why is it writ petition criminal?
Because of illegal detention, my for more than 24 hours, my lord. He was misbehaved, my lord. The sister has been misbehaved. I made a complaint before the SP, my lord. Nothing has been done, my lord.
Ultimately, you're paying for initiation of disciplinary proceedings.
Yes, my lord. OC, my lord.
And compensation.
OC has misbehaved with my sister, my lord. My lawyer has been misbehaved, my lord. Because Article 22(2), my lord, says that every person so arrested shall be produced before nearest minister.
We are receiving notice. Very nice. Heard Mr. P. Katogi, learned counsel for the petitioner. Agreed by the non-production of the petitioner before the jurisdictional magistrate within 24 hours of his arrest. The present writ petition has been filed for causing an inquiry into the police action for alleged illegal detention on 29/6/2024 to 30/6/2024 for compensation and for initiation of disciplinary action against the concerned police personnel. The present writ petition is in file under Article 26 of the Constitution of India. Explanation notice returnable in 4 weeks. We'll give a fixed date after 4 weeks. Mr. H.K. Hazarika, the government advocate, accepts notice on behalf of all the respondents.
No, Lordship.
No.
Oh,
Respondent
1 to
1 to
3. 1, 2, and 3. The petitioner shall take steps within 2 days for service of notice on the respondent number 4 by registered post with AD. Next one. In the meanwhile, the learned government advocate shall obtain instructions. Next one, this one. But give copies to.
Yes.
Item 3,
May I please? My lord, in this case, my lord, the petitioner's wife, my lord, are illegally detained by the respondent number 8. With the help of the other respondents, but no action has been taken by the concerned, my lord, state authorities. Till date, my lord.
No, because you see, the police here cannot do anything if he's in, if your wife has been taken away to Kolkata, they can at best register the FIR and then send it to the Kolkata for further investigation.
Yes, but that has been, my lord, lost intimation. Page 14, lordship will find. So far, my lord, page 14 is concerned, my lord, no action has been taken. Only GD number is there.
Because she's an adult, if she has left after decriminalization of a particular offense, what else can the police do?
But at least the, my lord, the person concerned should be, my lord, police before the, my lord, appropriate court. So that her statement should be recorded. It is purely, my lord, illegal detention.
No, but you see, we have our reservations that the government advocate addresses. You see, so far as the jurisdiction of a division bench is concerned, it is against a police action.
My lord.
But if it is police inaction, whether it will be a division bench, this, or you can file a complaint before the CJM.
Now, it is, my lord, in the nature of, my lord, habeas corpus.
No, because you know the where your wife is residing, you know the address where the wife is residing, and you are making a statement that she is voluntarily residing there.
ultimately, my lord, in any case, illegal detention is there. If there is an illegal detention,
No,
the
no. You see, a civilian cannot have illegal detention. He's having custody of your wife. So your remedy is under the family courts to have restoration or restitution, what you call, conjugal rights.
now, my lord, since he is my lord, illegally detained by the my lord, individual, so there
No,
is.
you see, there's a decriminalization of a particular offense. Now, if there's an adultery, then it's not a criminal action anymore.
But that would come in the light, my lord, if she is my lord, produced before the appropriate court. At least the investigation officer should my lord, produce the victim before the appropriate court, so that her statement should be recorded in the court of law. Then it will be class trial.
You get instructions, we'll take it up next week.
My lord will obtain instruction.
Because if the police has sent the what do you call had registered the FIR and sent it to Kolkata.
Kolkata authorities, my lord.
Today is Wednesday. We are taking up next Wednesday.
My lord.
Your FIR makes it very apparent.
Yes, that's true. That's true. But in any case, my lord, the victim should be recovered.
No, your FIR doesn't say she's a victim. They fled away and married.
Fled away.
Yes. Now, my lord, subsequently, my lord, it has come to the notice, my lord, she is illegally detained by the accused number 8.
On what basis? Have you got that information?
That should be, my lord, disclosed if her statement is recorded before the appropriate court.
No. Why, you see, if it is within your knowledge that your wife has fled away, what is there to investigate? Please tell us.
Now, at least the, my lord, the person concerned should be, my lord, brought before the court, so that her statement should be recorded. If her statement says, my lord, she voluntarily, my lord,
You file a proper suit for dissolution of your marriage.
that would be, my lord, after her recovery, my lord. If she is not recovered.
No, you see, there are two things. Number one, if you want to live with her, you'll have to, she's a married woman. Without a divorce, she can't go there. And therefore, you will have to file the only way is to file an application for restoration of conjugal rights.
That
You're
would
not
be, my
doing
lord,
that.
That,
You're
that
getting a
course,
shortcut.
my lord, that course would be, my lord, after her
No, that's a
statement is
shortcut.
recorded.
You see, you're in a division bench in a habeas corpus. We must understand the nature of complaint and then take action. When you say that your wife has left your matrimonial home, gone to live with another man, there's no case of habeas corpus.
Now, in any case, it is a illegal detention by the individual.
On
You
what
are saying
basis?
so. What
On
is your
what basis
basis?
are
I'm
you
asking
making
you
a
that.
statement?
Now, that has to be, my lord, disclosed after her statement is recorded before the appropriate court.
Oh, Mr. Mondal, you come back to your FIR. Your FIR is very clear and
Yes.
categorical.
That is clear.
And subsequently, that she was illegally detained is an information on what basis have you derived?
But we have been,
Or you want to say that the lady has to make a statement saying that she is illegally detained?
we have been, my lord, instructed so far.
So your instructions must have some basis. And your FIR is very clear.
That's true. That's true.
Then
But, my lord,
You see,
she should be.
you see, I'm good at giving horrible examples. Let me give you one. You see, we have called for assistance, Mr. Mr. Hussain sitting behind. No, don't say. No, don't come up. You will destroy my entire story. So we want Mr. Hussain to come here, and he does not come. So can I presume that his friend sitting in the in his side is illegally restraining him from coming forward?
you're praying for a heaviest court.
That would be, my lord, discovered after her statement recorded in the appropriate court of law.
Already married.
This is my, my lord, humble submission.
That is, you show us anything, because that can't be. On the basis of your,
You would have accepted your statement had this FIR not been there. Your FIR is absolutely categorical.
Yes, that is clear.
Then
That is
if it is
clear.
clear, then why are
In-
you making this statement?
you
In
see,
any
your,
case,
you see your, you would have been a wonderful husband. You don't know. You see, your wife went to your, her parental house. She stayed in the parental house, and from parental house, she went away with, respond number 8. So you see, it is not a case that the wife was abducted from your home. That's not your case. She went to your matrimonial home. You don't say why she left your matrimonial home. That is the first question. Why did the wife was compelled to leave your matrimonial home and go to her parental home? We don't know that story. From there, he fled, and her parents are not concerned. Parents don't say that my daughter was abducted. It is she went away from from a parental home. So please tell us, because there are many gaps which are here.
that is why, my lord, if she is not, my lord, recovered, we are also in a dark, my lord.
Where is your Kabinnama of your marriage?
Kabinnama is not there, but on
She
school
is your
certificate,
wife.
yes, on a school certificate is, my lord,
No. We are not concerned with age. Your marriage.
yes. Marriage, my lord, performs in the, my lord, temple, there is
which-
no such record. But one, my lord, birth certificate of their side has been annexed. my lord.
You see, you must go to a temple
Yes,
where marriages are conducted.
Well-
Like, for example, maybe a temple X,
my lord.
which performs marriage and then issues a certificate.
Correct.
Is the place where you got married a place recognized for marriage?
My lord, no such
You see,
certificate.
in front of a road, there may be a Shani Mandir. Some people have set up a Shani Mandir in the roadside. Can you go and say that I am married validly there?
That is there. That for that, my lord, only one certificate has been, my lord, annexed. Lordship, kindly page 12. The birth certificate of my baby, page 12, my lord.
Where is the baby?
Baby is in the, my lord, school.
With whom?
My lord, the father.
With you.
Now, her, my lord, school status
Where
is,
is our age certificate?
my lord,
Date of
page 12.
12/2011, right?
Where is a age certificate?
Age certificate, my lord.
School document. Where is that?
Page 12, my lord.
Page 12.
Yes, 12.
Birth certificate.
Sorry. School certificate.
Date of
Yes, birth certificate.
date of
This is
birth
birth certificate.
2011.
My lord.
2011.
Your wife was born in 2011.
The child.
Child.
The
Child.
child.
So where is your wife's?
Wife's name is there. Lordship will find Rekha Roy. Mother's name.
Name of mother.
And my lord, father is, my lord, Rupam Bokot. Lordship will find. Page 12.
How many children do you have?
Only one children.
Your certificate says 2. So you forgot 1.
And it is one set.
Good father. Your certificate says 2.
Second issue. Yes, well, I have been told, my lord, only one side. Maybe, my lord,
This is the problem with a busy lawyer.
now I have been instructed specifically, my lord, only one issue.
The papers are saying otherwise.
Yes.
Okay, 1 week.
At best, my lord, he can go to the family court.
No, we
What
don't know.
is the-
We
Can't
can't
advise.
advise.
Otherwise, also, my lord,
We
I'll
can't
obtain.
advise. We can
obtain the
record your
instructions.
statement, but we can't give advice.
Now, our limited period, my lord,
No, let us see what the police has done.
Yes.
Now we have understood what we are trying to understand from you.
Yes, ma'am.
Okay. Mr. M.U. Mandal, Learned Counsel for the petitioner, projects that the wife of the petitioner has referred to the FIR lodged by the petitioner on 15/7/2024, alleging that his wife had fled away from her parental home and is currently staying with the respondent number 8 after solemnizing marriage. Full stop. As it privacy appears, that the petitioner is aware of marriage of his alleged wife with respondent number 8, comma. At this stage, we are inclined to seek instructions from the no, seek the no. First of the said FIR. Please continue from there. The said FIR. No, don't say that. Because, accordingly, we direct the officer in charge of Halakura, HALAKURA police station. No, it's not a police station. It is Halakura PCP. It is PCP or POP?
Police outpost.
POP. POP to give the status report of the status report in connection with the projected FIR lodged by the petitioner on 15/7/2024. The name of the petitioner Rupam Bhakat on 15/7/2024. Post of the Miss
U Sharma.
U Sharma, done government advocate, accepts. They shall send a downloaded copy of this order to the concerned. This is under Golagaji police station.
Under Golagos police.
Shall send a copy of this order to the officer in charge of Golagaji police station to furnish her with the status report with regard to FIR dated 15/7/2024, stated to have been lodged before the officer in charge of Hatikura POP. List on after 7 days, make it 28/8/2024.
I see Halakura police outpost.
Halakura, HALAKURA.
Deep population.
Item 4,
May I please, Your Lordship? Occasional Lordship directing.
Directors me to obtain instruction as regards the annexer 3 in page 31, whether it was issued by the election department or not, Your Honor.
31.
Yes, Your Honor, page 31, annexer 3. It's a voter list of 1985.
Yes.
Certainly. As per my instruction, Your Honor, this has been duly issued by the department, Your Honor, and they have sent me the authenticate copy. As regards the relevant page, I have given a green flag.
Okay.
It's serial number 415.
Serial number
415.
415.
Amjad Ali, house number 15. Name is
Amjad Ali.
Amjad Ali Mutab.
So, okay, then we are issuing a notice then. Yes, in the matter. Ms. Verma, we are issuing a notice now. records, we have already called. So record is not received. It has come.
Record is available.
What is the serial number?
Serial number 415, page number 5. House number 15.
Oh, I think he takes let's see. So the got an impression that revenue permission closed. Oh, no, this is an ex parte opinion. This is that case, Ms. Verma, where he thought that the foreigners travel has permanently closed. He was absent all throughout. From 18/5/2015, the petitioner is absent till
Yes.
3/6/2016.
Yes, Lordship.
He claims to have appeared on a date which is not the date fixed for the case, and then has an impression that
It was closed and that was
and the
supposed to
day
be
he went,
Janmashtami holiday.
on the last date we found from the calendar
Calendar.
that it was a holiday,
Janmashtami holiday.
Janmashtami holiday.
Yes, Lordship.
That is this case.
Lordship, but apart from that also, the conduct of the petitioner, Lordship will see so many ample opportunity was given and she sought adjournment again and again. Lordship, if Lordship
No adjournment, that is, the petitioner is completely absent
completely Lordship
from 2015.
and without steps,
No,
Lordship.
without steps.
In case Lordship decides to send it back, Lordship will impose a heavy cost on this Lordship. From 14 to Lordship will see till 16.
No, that is not the submission. That is why we said that
Daily wage.
he saved the time of the court to make that submission. He is ready to pay cost.
Lordship may
Acha, have you taken bail? What is your instructions? So unless you take bail,
Yes,
you will
Lordship,
not.
yes. He appeared and obtained the bail, Lordship.
on 24/7 Lordship had granted him interim.
Whether he is appeared.
Appeared, Lordship.
Let them find out. We'll take it up next week. You find out, please, that whether it has taken bail.
As per instruction, Lordship, he appeared.
We
But
can
it-
take it up now only, Lordship. We can give a call and find out.
Find out.
After some time, Lordship may
Because
take it up.
the idea is very clear that if he has taken the bill, then only we set aside the order. Otherwise, we set aside the order, he vanishes, nowhere to be found.
You get the instruction.
Oh, yeah.
Ask her.
Oh, I know.
After some time.
After some time, once we get it, we'll inform Lordship.
After some time.
Lordship, I have 2 matters, Lordship. Please accommodate me, Lordship. Oblige me.
Item 5,
May please, Lordship, the contested case, Lordship, the LCR was called for, Lordship.
Yes.
Lordship.
How have you connected to your projected parents
Lordship, the page 24, Lordships,
page?
24, total list 1966, Lordship, 24, Lordship. Abdul Sheikh, Lordship, is my father, Lordship. Solimuddin Munshi, grandfather. And Lordship 17, page Lordship 26, Lordship. Abdul Sheikh, father Solimuddin Munshi, Lordship. And page Lordship 31, Lordship.
Just a moment.
What is the name of 66 voters list? No, 66 of কোন আছে? কোনটো কি নাম? 66 আব্দুল
What is the name of your grandfather?
সলিমুদ্দিন মুন্সি লস্যি সলিমুদ্দিন
I don't know which serial number. এটা আব্দুল সামাদ সামসুং কোনটো ফাইল আপনার কোনটো ডিস্ট্রিক্ট? হুগলি আমার বরপেটা এখানে মিলা নাই।
And who is Mafijuddin Sheikh?
Mohazuddin Sheikh is the Negibar লস্যি Negibar লস্যি
Elder brother.
Kobilez লস্যি and lordship the page 31 lordship. My name is along with my father lordship. 31 lordship. Yes. 1985 border list.
Was your brother examined as witness?
Lordship, the DW1 is the petitioner and then DW2 is the brother lordship. Submitted the written evidence but not cross-examination due to illness and later on died lordship is DW2 lordship. In the meantime, the impugned judgment was passed lordship. Case lordship 60 is the death certificate. DW2.
Nineteen 66, which village?
Boldiar par Algersor non-kill.
Boldiar Algasar Nanke.
Non-kill.
Now, where were you in 1970?
97 is the Boldiar Alga Sor non-kill. Same
Okay.
village.
After 1970, you are, which is your voters list?
Well, it is 70 is the same village lordship the and lordship the 77 in Boda list lordship 1977 is my name is their lordship. Page 28 lordship.
28. So this is a different village.
It was due to erosion lordship, the shift lordship. Under same police station, same subdivision lordship.
But it appears that you are not the family member. You see, come to page 48, 49 rather. The Kachapata. Here, your name is not there. So you're not a son.
Lordship, my father's name is there, Lordship.
No,
Short name, Lordship.
no.
Sheikh, Lordship.
No. You see, we are
And-
not disputing your father's name.
Lordship,
Your brother's name is there.
no, Akbar Ali. Akbar Ali is the
Not
uncle.
Akbar Ali.
Akbar Ali is the
Not Akbar Ali. Next name is Mofizuddin is your elder brother.
Mofizuddin's father's name is Jubbar Ali.
No, you just told us.
Page 49.
You
Lordship.
see,
Yes,
then
what-
it doesn't match. 66 voters list, you say is your brother, Mofizuddin. Now, Mofizuddin's father is different.
Different, Lordship.
Then you're not a family member.
He is not family member, Lordship.
Then how in 1966 he is with your projected father and grandfather? You said he was an elder brother.
66 voter list, the Lordship, the fathers is Abdul Sheikh, Lordship. Abdul Sheikh and Solimuddin Munshi is the grandfather.
Solimuddin, and then we asked you specifically about Mofizuddin. You said he was your elder brother. We asked you twice.
Mofizuddin's father's name is Lordship Jabbar. My father's name is Abdul Sheikh.
That's why we asked you. You said he's your brother.
Lordship,
You see, you're not annexing the entire voters list. You are entering, you have obtained certified copy of 3 people. There must be some relationship with Mofizuddin. If he's not your family member and his name and is entered in the land records, that means in the exclusion of you. Because in your evidence, you say that Mofizuddin is your cousin brother, but you have not described your relationship with him. In the family tree is not there.
In Douglas Lordships, he stated that his family members only.
Which paragraph?
The Lordship, page 19, Lordship, paragraph 9, Lordship. That of his father name, namely Abdul Sheikh, son of Solimuddin, is about 50 years, along with his family members, namely Solimuddin Munshi, son of Alihuddin, is about Mofizuddin Sheikh, son of Jabbar Ali, is about
So this is not your relation.
Family
You
members.
don't say that he is your relation. You just give 3 names.
family.
You have a voters list with 3 names, you give a reference of 3 names. Your relationship with Mofizuddin is not stated in your written statement.
My Lordship.
So where is a document to connect you with your father?
85 border list, Lordship. Page 31. Barnacle Lordship, 1985.
একটু ট্রান্সলেশন দেয়া নাই না
Abdul Sheikh Lordship, the father, Sabiri Khatun is mother, Sahibul is the petitioner. Naib Ali and Muhammad Ali is the brother.
What is the name of your mother?
Sabiri Khatun.
Huh?
Sabiri Khatun.
Saberi.
77 voters list, her name is different again. It is Sahatan Bibi Lordship. And even the age discrepancy is.
77 was not placed, not brought in evidence.
The program.
Lordship, 66 voters list shows the father's age as 50 70 shows it as 54 and again 77 shows as 55.
But 77 was not produced before
In the opinion, you will find that.
Yes,
the
Lord.
opinion.
In the opinion, you will find reference to voters list, it's not there.
77.
Get it? Mhm. P807. Of 2006. You show it here, then. In the readout. Name of the parties is available. P807 of 2006. It's showing different name. And 7669, another one. Of 2016. Ah, yes, one printout of that. Huh. Give only one printout. There will be. Any number P807, make it 16 and then see. Maybe it's 16, not 6. It's there, huh? It's there. Then get it. Get that. Okay.
आता विश्वान મને તો બીજી નામો आहे फाईल बेलेग नामो क्यों करें क्यों करें तो ये नाम तो बेले ये नाम तो बेले करने को yes
No.
yes lordship
In the trial court, what has happened was that privacy appears to us that the photocopy of the certified copy of the voters list was exhibited. So that is inadmissible. And that is why these two judgments were referred, Ramila Khatun and
Boran Ali
this Because there's one more, Borhan Ali,
Yes, Lordship.
and it was rejected. So the certified copies were never proved, and the documents are also not compared documents. It's not proved in original. So therefore, the court has rightly rejected it, and can you improve it?
As the original Dian also photocopy the district. Photocopy the proof for a night. Photocopy the proof for a night. তাতে লেখা আছে না opinion to doc. No document. Seven. Oh, yeah, document 77 or they say. Itu nama 77. 77. এই বাড়ি সে চাহি বাড়ি এতিয়া আমি তো নাম আহিবে চেবালি এই চেবালিটো ইয়াতে আছে
Lordship, after compare the original was returned, Lordship. The Lordship exhibit mark is there, signature is there.
Itu lang.
Yes.
He says he has it. Good. Compared with passing the order it has a Xerox copy. Lordship,
If
original was
the-
not there, Lordship. It is marked here also.
No. It's here, original.
Yes,
Original court exhibits signatures are there.
yes, Lordship.
Then this judgment will be incorrectly applied. Yes. Yes. The original signature of the tribunal is there. Then it could not have been decided. These two cases are incorrectly applied. You see, we'll give you this. This is that Burhan Ali.
Yes, Lordship.
You see 21.7. This order can be bifurcated in two parts. You see, 21.7 is very clear. Now, in this case, what has happened was similar to the present case, photocopy was exhibited. And therefore, that was in next page, you will find that was rejected. So, but the principle laid down is this a certified copy is admissible. In the next page, you will find the narration, the copies are not the certified copies. Those were photocopies.
Insist on the proof.
That's why my esteemed brother has read it and then underlined. The principle laid down is something else. And it was rejected because of the fact that
Nothing-
photocopies were there.
Yes.
And the original, what you call voters list was not produced. Therefore, court rejected it.
And it has to be produced by the electoral registration officer to come and prove it.
No, when it is a photocopy.
Yes.
But when it's a certified copy, the Asgar is not a authority on the point that certified copies can be rejected. This brings to the query we raised earlier. You remember we asked that question a few days back.
Yes, Lord.
whether this is a civil proceeding or a proceeding of criminal nature. Because
Whether CPC would be applicable or not, Lord, for the town. There is the judgment of the Justice Sharma Lordship, which says that CPC would not be applicable to this because it has its own rules and act, and it comes under 6A Lordship on the.
procedure is under the foreigner's order
Lordship.
64, therefore CPC doesn't apply.
CPC doesn't apply. That order of Justice B.K. Sharma is their Lordship. I
Oh,
tried.
last time you showed
Yes,
it.
Lord. It is very clear. Subsequently, Justice Ujjwal Bhai had also passed similar orders.
Precision of evidence.
Yeah.
খুব হালকে দিছে। It is. By comparing with the primary evidence that is the electronic key original produced and testified before the tribunal or by the court. Certificate copy of sorry, sir. This is session. Support, important bits and pieces. You'll be sorry. It processes. Insist on proof of contents of such certified copies, by comparing with the primary evidence. Insist on proof of contents such certified. মানে যদিও লেখা আছে certified copy তার শুধু বিচাৰিব লাগে। হ'ব পাৰি because it's in public domain which have been suspected we will not change. Certified copy of person. Oh, he has disagreed by the view taken. Filing on Jhantar, therefore we will respectfully disagree with the view taken by the Odisha High Court. Yes, Lordship.
Any authority on the point as to how rigid the approach of the tribunal should be when it comes to Evidence Act? Any authority on the point? Whether the provisions of Evidence Act applies proprio vigore with full strength, or only the spirit of Evidence Act is followed? Is there any authority on the point?
It is widely used, Lordship. Most of the times in case of documents, Evidence Act has a role to play here.
No, but to what extent? Just like you said, in civil procedure and spirit applies
Yes, Lordship.
because of its own procedure. What about the Evidence Act? Any authoritative judgment?
We'll have to look into that, Lordship. Lordship, another.
You
thing-
have any idea of the law laid down by this court on the Evidence Act, application of Evidence Act in the, Mr. Ahmed?
On the tribunals
Application
proceeding.
of Evidence Act in the tribunal, do you have any authority on the point?
The lordship, in the judgment is not reflected the evidence. Evidence.
Muslim Mandal is there,
Muslim
Lordship.
Mandal.
Lordship,
Ordinance.
if we read this paragraph again, Lordship had pointed out 21.7. That was, the court had disagreed with the views taken by the Odisha High Court. Then Lordship 21.8, that is the problem which we are facing here because documents are suspected not to be correct. So if Lordship, I may just read the paragraph. After 21.7, where the court has disagreed, Lordship, 21.8 says there is one more aspect. Under such, though under Section 79 of the Evidence Act, there is presumption as to the genuineness of certified copies, provided that such document is substantially in the form and purpose to be executed in the manner directed by law in that behalf. It is in the public domain that citizenship is a contentious issue insofar the state of Assam is concerned. There are 100 foreigners tribunals functioning in the state of Assam, which are mandated under the law to answer references made to them by the referral authority, that is concerned Superintendent of Police Border, as to whether the proceedee is a foreigner or not. Simultaneously, process is on for finalizing or rather updating the NRC in the state of Assam. In both the processes, proceedee or the claimant, as the case may be, primarily rely upon voters list to prove their citizenship. It is also in public domain that a large number of voters lists have been detected which have been suspected to be not genuine. Therefore, notwithstanding the presumption of genuineness under section 79, it would be safe for the tribunals and the courts to insist on proof of contents of such certified copies by comparing with the primary evidence, that is electoral
pause
roll.
for a moment here. Now you see, the court is very sanguine when it's referring to this statement, when it's making that statement.
Yes, Lordship.
That means it would be incumbent on the part of the tribunals to do it. So supposing a person is, it appears that the intention of the court
Yes, Lordship.
was that if somebody is producing a certified copy and you disbelieve it, then the tribunal should call for the original one.
Yes.
But that was not done. You see, what
The-
happens is that you think of a common man. He goes to a court, gives a certified copy. There's another aspect of certified copy which will come later, not at this stage. Certified copy is produced, no questions asked, and then it is disbelieved in the opinion. So what happens to the,
Maybe the tribunal missed a step by not calling the electoral officer, Lordship, the electoral registration officer to verify the documents.
then
Maybe she skipped a step.
then it's a
Lordship.
case of remand.
Yes. Otherwise, if she's following Borhan Ali, she should have followed the procedure completely,
Completely.
in totality, Lordship.
Because citizenship can't be lost because when the certified copy is there, there's
Yes,
no,
Lord.
no objection is to the genuineness.
So maybe Lordship may remand the matter on the grounds that the electoral registration officer may come with the original ones. Lordship, in many matters, when they have appeared there with the original records, they do not tally, they do not match at all. So even the extract copy which is exhibited or annexed sometimes with the writ petition, that is also not to be taken at face value, Lordship. So if the
No, you see,
member has missed a step, Lordship may
no, no.
remand it back and with this specific
No,
observation.
you see, for that, we must be guided by some submission made by either side.
Yes,
You
Lordship.
see, the petitioner produces a certified copy, you don't object. We are not expected to look into the certified copy and question its genuineness.
Authenticity, yes,
And
Lordship.
Lordship, the one authenticity report was received by the tribunal from the election officer, Lordship. In the judgment, Lordship, page 65, Lordship.
65, it says, Lordship, the submitted voters list are verified by the OP from the election office Dhubri. Then again she writes, the election office reported
election
that the
office-
South Salmara
Where you are
LAC,
reading, which 65, which part?
65, second paragraph.
Second paragraph.
The
The
submitted voter lists are verified by OP from the election office Dhubri. The election office reported that South Salmara LAC and Mankachar LAC do not fall under the Dhubri jurisdiction. After that, the submitted voters list are verified by OP from the election office South Salmara, and the election office South Salmara sent an authentication report. But all the voter lists are certified copy, and hence the contents of the documents is not proved by the authority, and hence these exhibits cannot tallying with the primary evidence.
report is there, Lordship.
No, report is there,
Report
Lordship,
is
but
there,
it is
Lordship.
not tallying.
After verify the send the report.
Those records.
Records are here, Lordship.
Hmm.
Lordship, I'm giving the judgment already.
This is. Something which is.
On that side, this is report.
Yes, given. Evidence I think we assess a much. अच्छा साउथ माने साउथ सालमारा माने Pachar couldn't distribute for it. Because he did not fall under the jurisdiction election officer report this.
20 district rules.
Ali not South Salmara couldn't distribute for it. It is opinion picture. 23 opinion picture or the bifurcation. South Salmara Manpachar. Lordship, maybe because of the bifurcation of the districts.
No, just a moment. Just a moment.
Yes, Lordship.
Because the petition steps, issue sounds production. Just need this.
This sounds pretty good, right? That's what we do, so South Salmara.
Witness. Yes, we first. Okay, absent today, engaged with petition with the prayer for absence for shown petition report from auxiliary times. Exposed. 323. Confirmatory course.
You have the authentication report. Authentication report table में घुसाना ना, वो भी नीचे आने से. Ali, election officer authentication report picture पर दिया तो आगे. Election officer authentication report दिया तो पता नहीं. अरे verify भी करेगा जाके. There is nothing called authentication report. यूटी भी सारा ना, यूटी नीचे भी रहने से. हाँ ठीक है. यूटी फाइल हुआ. साहेब वाली फाइल. Page 65 से पढ़ा. Lordship, another thing which I have found in the opinion is the OP went and got an authentication report. The court never called for it.
No,
Yes, so if, how can
No,
the
no.
OP get this?
OP has
lordship?
taken
No,
steps
you see,
one way.
what has happened, we don't know. Number one, we found that the petitioner has taken steps.
Steps, Lordship.
After that, he abandoned it. And then after that, the petition was rejected. He filed an application for recalling of that order and to allow him to take steps. He took steps, but after this report came. Now, how this report came, we are not inquiring into that. Correct?
But there's nothing,
Yes,
called
yes, he has taken
authentication
steps.
report come from the election office. They have to come and verify. Till
No.
date, we have never heard about
We
this.
we are not looking at the manner in which it was done.
Yes, Lordship.
But the document has come
Yes, Lordship.
and the tribunal takes cognizance of it. The question is if the tribunal would have rejected that, saying that you were asked to take steps for summoning of the witness. Instead of summons, you have sent the report. Now, he is not an authority within the meaning of, we did not really go into it. They are
Yes.
not authorities within the meaning of 293 of the evidence of the CRPC,
Yeah.
where certain class of people are exempted. So we are not on that. But the fact is that if the court takes cognizance, then it becomes an evidence.
It should have directly rejected instead of
that we don't
directly
know. That is
rejected, it's
for-
also not there.
That's why we are saying that the Home Department should do what it should do.
Yes, Lordship.
Use this yellow flag. You go through it in the meantime. We take a small break and come back.
Yes, Lordship.
You see, the trouble lies when the procedural aspect is not, there's no, what you call, for the lawyers and for us also. If we don't take the law relating to evidence or procedural law as it is, then there's two things. My brother did put a question. You see, the burden lies on under 9
On the
for the
procedure.
petitioner. So that can be extended to how much? If the documents are there, if the court takes cognizance of documents, and then you read this, then you will find what we are wanting to say. You read this, the yellow flag, read the document, then we'll tell you.
May I read it, Lordship? Here at this stage, the difference between a tribunal and a court must be stated, Lordship. The tribunal is established for quick disposal of the matters sent to it, unlike a regular court. The laws of evidence are not strictly applicable in a tribunal. Courts exercise judicial power to the state to maintain and uphold the rights of the citizens. It punishes the wrongdoers and adjudicates upon disputes. The tribunal, on the other hand, are special alternative constitutional mechanisms usually established under statute to decide disputes arising with reference to that particular statute. In Union versus Swinford, the Supreme Court has held as under. Though both courts and tribunals exercise judicial power and discharge similar functions, there are certain well-recognized differences between courts and tribunals. They are courts are established by the state and are entrusted with the state's inherent judicial power for administration of justice in general. Tribunals are established under a statute to adjudicate upon disputes arising under the said statute or disputes of a specified nature. Therefore, all courts are tribunals, but all tribunals are not courts. Courts are exclusively manned by judges. Tribunals can have a judge as the sole member or can have a combination of a judicial member or a technical member who is an expert in the field to which tribunal relates. Some highly specialized fact-finding tribunals may have only technical members, but they are rare and are exceptions. While courts are governed by detailed statutory procedural rules, in particular the CPC and Evidence Act, requiring an elaborate procedure in decision making, tribunals generally regulate their own procedure, applying the provisions of the Code of Civil Procedure only where it is required and without being restricted by the strict rules of evidence act. Reverting to the case in hand, the strict rules of evidence are not applicable in a tribunal. Nothing is required to be proved beyond all reasonable doubt. We find that the observation of the tribunal pertaining to Swinford's powers and therefore the entire opinion the tribunal suffers from control. Lordship, this is the judgment. And
So it is not strictly applied.
in this matter, it was remanded back to the tribunal. Lordship.
Not strictly apply, where is it also?
Proceed. One question.
Lordship.
Just one.
Once more, we can.
Just a moment. Brother is examining this. Just one minute.
You can tell.
Hmm?
Let us come back. Something only there.
Because with this parameter, this judgment which you have shown, I think this is a case which calls for a remand. Because the rightly or wrongly, something has come from the Election Commission. They have,
Yes.
you have seen that document. So I think it has been wrongly appreciated. They go to the extent of saying that it is genuine.
Genuine.
That is one. Second, they have given an explanation as to what mistake they have done in issuing a certified copy. So this is not a opinion which is against the petitioner.
Under what circumstances this was issued is also another question, Lordship.
No, that's why you say we can't, because you don't have really time to go through it. You see, you have the record with you. You please find out if the summons to the election officer was issued under which provision. If you have the record, you can find out. We'll take it up after some time. In the meantime, you can go through the record. The summons to the election officer was issued under which provision. Then we'll be clear at how it came. Because the copy of summons is not there.
It's not here in the records.
At least I did not find it, but you have seen the speed with which I have gone through. I may not have taken note of each and every document there, but the copy of summons apparently is not there.
half records.
Huh?
You don't get complete records.
No, no. You see, that's why we are saying we don't know what has happened. But in the order sheet, you'll find we have flagged that order. 2 orders we have flagged. So notice was issued. And the tribunal take notes of the presence of the electoral officer's report. First is there is an order, then there is a rejection. After that, there is a recalling of that order, issuance of fresh summons. And this is
We have not, that is the question. Instead of him coming, maybe the report came in.
we don't know. There's a missing link. We don't know how it happened. In the order sheet, they have stated that so and so is received. Please read that order.
The petition with a prayer for absence cause shown. Petition allowed report from election office Hafiz Sindhi Mari comes and tagged.
So comes. It is not produced by the petitioner. He is absent.
Is absent.
And therefore the tribunal takes cognizance of that.
Six order says OP is present, engaged advocate filed a petition with a prayer for time and also to vacate the previous order of.
There is an earlier order closing it. After taking steps, the petitioner had taken a lot of time. Steps was not taken and therefore it was rejected. Again, it was recalled.
Hearing also. And then date of ex parte hearing. The engaged counsel comes up with a medical certificate.
That medical certificate also we have seen. It's there on record.
DW2, medical certificate of DW.
DW2, that was for
And later
DW2.
on, later
And
on.
after that, he told the court in 21. He tells the court that in 19 the
Expired.
DW2 expired.
Expired.
And after on the next date, he produces a death certificate also.
Yes.
After 1 or 2 pages, you'll find a death certificate.
Death certificate.
No, not there. Somewhere where that petition is filed.
Repetition is there, page 60.
References and logicability now, when the reference wasn't Shaib Ali, then again it became Sahib Ali. By the time it reached this High Court, again one more name has been added, Saib Ali. So the name also keeps on getting added with each proceeding logic. Maybe the documents to match with the documents which are being produced before logic. Other thing, logic, so many shiftings, 3 shiftings are there.
But the voters list are there. There's no, you see the cross-exam we have flagged. This is again a very good example of cross-examination. Because if I am permitted to use the word, I'll use the word of confirmatory cross-examination.
Interestingly, how the name keeps adding up logic, because one document is in Sahib Ali, another is in Sahib, another is in Shaib. So the aliases goes on increasing with each document.
Yes, only two. Sahibal
No.
is Sahibal.
He is always Sahib Ali
Sahibal.
because
The reference is the name of Shaib Ali, SHE
No, that's an English of Assamese.
That's it.
Because the language is the certified copies of the voters list always say same name.
Something.
At times it is added, it is clubbed. Saeb Ali. So maybe somebody is writing Shoaib Ali, SHOAIB or Shoaib Ali. But in Assamese it is same.
Same. Sorry.
The spelling does not change.
My humble prayer, Lordship, the remand back the matter, Lordship, that
No, that is, let
Verify
the
that.
state be very sure.
Also, it's better.
Sometimes they take it about 1 year.
Very good.
2019, it was a COVID period. Pre-COVID. Death certificate is about.
But if the order sheet is reflected that we have recalled summons,
No,
not proceeding,
no. DW1, DW2 was closed.
election officers.
It was closed. After that, petition to recall, so it was recalled. Whatever, closure is recalled.
But they never appeared.
No, but the report was sent. When I had to, the audit was sent. It was also taken. They can keep the report. I will say. But the report to accept the report. I'm getting a deal. I'm not that clear. It will kill it. Missing link which we could not take out is that nature of summons issued. That we could not track. I'm in fact losing touch of going through the trial court record and find it out. Okay, we'll see and we'll examine what orders we have passed. We are not saying what orders we are passing, but let us examine the records in chambers. If for some reason we are not satisfied, we'll list it again. Because we have, yeah.
Recording the.
Okay, so. Has, okay. Okay. 8 to 30 minutes. This original we are keeping. You just remember and take it from the
Plus-
conference.
Lordship, item 6 for adjournment today, Lordship. Item 6.
Just wait, let one by one end. Mr. Order. Chamber. Ahmed, Mrs. Burma, Mr. AI Ali, and Ms. H.K. Hazarika. Just write the names. Okay.
Biplab.
Item 6.
6, you are paying for adjournment.
Adjournment.
Okay. Yes. Both sides are represented on the prayer made by council for the inspiration. Interesting is adjourned today. Just after 2 weeks.
Biplab.
So if you were here, we take up your matter.
Time being item 4.
Okay. Since he has taken bail, we'll pass orders in the chambers.
Enforce false logic. From 19 to 23 logic did not appear, no steps taken. 2016 order logic.
We've seen that we have that note. His absence was 1, 2, 3, 4, 5, 6, 7, 8. 8, 9. 9 absence. Okay. Here, Mr. F.U. over here for the petitioner and respondent same name. Chambers.
Obliged, Lucy. Petitioner is a daily wage labor, Lucy. That's why take into consideration. Obliged, Lucy. My learned friends saying it may be important. I leave it before your lordships.
If you leave it, you are imposing it.
Lordship, discussion here applied, lordship.
What will you call a person who goes to stock exchange daily in Bombay bourse and trades for a day?
There's a rare person sometimes.
They are also daily laborer.
But that is rare. But he is a.
But what would be the daily earning? We don't know. Therefore, we
He
don't ask. Even if he's a daily wage earner.
Work in the big industry.
No, that is okay. But out of to maintain some decency, we don't ask your income. So therefore, we don't know daily wage. He's a daily wage earner. And incidentally, whether you know or not, I don't know. But both of us, at one point of time, were daily wage earners.
Yes, Lord. So we are all.
I don't know about you, but for us, you can say with
He's a
certainty.
labor, lordship. Labor.
Daily we used to give Hajira at one point of time. Without Hajira, we crossed that Hajira stage we crossed.
Here is the case of poor workers.
And
Obliged.
I should apologize to my brother.
No apologies for it. Exactly classify that criteria.
Okay, next.
Item 7.
Wait, please, your lordships. Lordships.
Classification still.
7.
Yes, deportation.
Lordship, this is the Rohingya matter, Lordship. On the last occasion, your lordships were pleased to pass orders directing the detention camp authority to make arrangements for the petitioner to have the refugee status with the UN Commission. UN High Commission, and the copy was furnished to the authority. And as per our instruction, from Delhi, 2 personnel came to the detention camp and interview has been done. And further interview may not be required. That has been informed to us by the person in the commission through SMS law. And the
'Cause we just have to adjourn it. They are examining the matter. Four weeks?
Your lordship.
No, because we have no control over that matter.
Yes,
We-
lordship,
UNH,
yes,
they are looking at it.
So the process is on, lordship,
Process
as
is
per
on.
our
Okay.
permission.
Okay.
Any date may be fixed.
But Mr. Zaid Hussain, and counsel for the petitioner, as well as Mr. R.K.D. Chaudhary and DSGI, appearing for Union of India, Ms. Mr. G. Sharma, and standing counsel for the Home Department, Mr. A.I. Ali, and standing counsel for the Election Commission of India, that's Mr. H.K. Hazarika, and government advocate for the state. Next paragraph. Pursuant to order dated 29/7 to 2024, comma, the learned DSGI has. Oh, no, this is produced by you. Okay, Mr. G. Sharma, and standing counsel for the FTN border matters, has produced a copy of communication dated 19/8/2024 from the Inspector General of Prisons, as well as a copy of communication dated 28/2024 issued by the Joint Secretary to the Government of Assam, comma, political within bracket B, bracket close department, which indicates that the UNHCR representatives have gathered information and evidence regarding the claim of the petitioner for refugee status, and they would review the case and take a decision in the matter. Full stop. Next paragraph, the learned counsel for the petitioner also submits that as per instructions received by him, comma, the process of the UNHCR is processing the claim of the petitioner, full stop, in the said communications are made a part of is written in the record. Scan copy. Is made a part of record. Full stop. As the matter is being examined by the UNHCR, comma, the court is inclined to adjourn the matter. List on, give a date after 4 weeks. We can make it 20 September. 20 September. Yeah, very last week will be pre-puja. So,
Deputy Solicitor General
site video, customer did you? Yes.
Item 8.
May please, your lordship. Here in this case, my lord, we have challenged the expert out.
Yes, yes, what is that? That is a report from the inspector. Border Borpeta.
This petition was filed saying that they are not the same person, lordship, and police was harassing them. That was the submissions of the petitioner. But after getting the report now, we placed it before the court that both are one and the same person. On being declared a D voter, he subsequently changed the name and wish to get documents in the name of Samuel Wilson.
We have serious objection to the plea, my lord, that after debutar, he sends the name. This, we have serious objection to this.
That's
The
okay, but
demarking itself is illegal. my lord.
no, that
And-
there's a expert opinion.
Yes, my lord. Expert, we are against the expert opinion.
Yes, after the documents in which the names are changed.
My lord, 89 voter list, her mother's name was recorded as, her name was recorded as Mahemon.
Just a moment.
Then 97,
Just a moment. Yes, please repeat again.
my lord, in 97 voter list, her name first time appeared as Mahemon, my lord. It- 93 voter list.
90,
We have 93, 89 voter list, sorry, my lord, 89 voter list. I have annexed in annexer 11, page 41, where her name
Just-
has
just
been
a-
recorded as Mahemon Khatun.
just a moment. Page 41.
Page 40, my lord, 1, my lord, 11% 42.
Yes.
Then, my lord, in 97, she has been, as per the voter list, her name is recorded as Sap Khatun. My
This
lord,
is
and
page-
she was marked as a D voter.
This is page.
My lord, that I have not annexed, my lord, a certificate copy, and that I have not annexed, my lord.
After 89, what is annexed before this court is 2008, after 20 years, the correct name petition, the correct name of the petitioner appears in the electoral roll of.
No, just we'll come back to you. He's trying to understand what Mr. Sigil is saying.
No, he was. Okay.
Yes, then
Then, my lord, 97 voter list we have not annexed. She was marked as a D voter. Then, my lord, subsequently, that was not our knowledge, my lord. Then, my lord, from 2008 onwards, her name has been recorded as Shaimun Nessa. That is her correct name. 89 voter list, that is also not correct name.
you please refer to the documents so that it's easy
My
for
lord.
us to understand.
My lord, the documents we have annexed, my lord, 2008 voter list at page 43. Then
Just a moment. 43.
43. Page 43, 11, page 44.
Okay, we'll reassemble after lunch.
My lord. Three, 11 portion is at page 44. Then, my lord, 2016 and 2024 also produced similarly recorded, man. Now, my lord, I have also got a voter list of 2005, my lord, by WhatsApp message. That also indicates that her name is recorded as Simon Nessa. Two 2016 at page 45, 11% at page 46. Then, my lord, 2024 voter list at page 47, 11% at page 48. So, my submission. আছে কার্ডিও সার্টিফিকেট ইস্যু করেছে 15
In view of the affidavit filed by the petitioner saying that all three are same person, we permit her to take bail. And thereafter, after she takes bail and reports us to the court that she has taken bail, then perhaps we'll remand the matter for adjudication before the tribunal with considering the.
Yes, that is the best proposition, that's what my understanding also.
Because once we permit her to take bail, then she is available.
Yes. Otherwise, if your lordship may direct, they will definitely appear before the. I don't think they will invent by this law.
No. You see, the reason is that we are setting aside that FT order.
Yes.
If we set it aside,
Direct, have to appear before. By giving some time.
since we'll set it aside, we want to also ensure that the reference is taken up again.
Only thing is that, my lord, the petitioner who actually now not accepting, because he is the same person. She tried to event the proceed earlier.
My lord, that is, my lord, objectionable. That is objectionable.
Your original argument was that only, there are two different persons.
My lord,
It was.
my lord, because the voter list are prepared casually, my lord.
No. There is a shift in your original stand because you were the argument which we remember was that the original procedure was Sab Khatun, but the police is now searching for you, and your name is Simon Nessa. That was the change. That was the stand. Now with
Well,
this affidavit, at least when you are admitting that you are one
Yes, ma'am.
person, so we allow you to take bail
My lord,
and let the matter be determined.
my lord. My lord,
Because
only
we are
point,
not going into those questions whether what has happened earlier, what has not happened earlier.
my
So
lord,
because if we say that, then we take cognizance of the earlier opinion and then proceed according to that. So then there is no point in sending it back. Then we adjudicate the matter. So therefore, we are suggesting that since since you have admitted,
my lord.
now we allow you to take bail, and after 2 weeks, we demand the matter once you take bail.
My lord, we will take bail, my lord.
And after payment of costs.
My lord, if it is, my lord, remanded, my lord, at this stage,
No,
my lord.
because we'll be setting aside the order.
Yes, my lord.
But then we have we also want to ensure that the persons go to the tribunal and then appear and within time, and then the proceeding takes place. With that, we ensure at least the proceeding takes place.
Right.
Heard Mr. A.R. Sigdar, learned counsel for the petitioner. Also heard Mr. B. Chakravarti, learned CGC. Oh, you are for? For election commissioner. So we are Mr. B. Chakravarti for learned CGC. Mr. J. Pang, learned counsel for the Foreigners Tribunal. Ms. P. Barwa, learned standing counsel for the ECI. And Mr. H.K. Talukdar, learned government advocate. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner has filed an additional affidavit on 9/8/2024, whereby she has admitted that that Sahemon Nessa, SHAHEMON Nessa, comma, Sab Khatun, SAP, KHATUN, and Mahemon, MAHEMON, Khatun, are one and same person. Full stop. The said affidavit is sworn in the name of Sahemon Nessa. Full stop. Next paragraph. The learned standing counsel for the Foreigners Tribunal has also referred to an affidavit in opposition filed by respondent number 4 on 16/8/2024. And it is submitted that on the local inquiry, comma, Sahebon Nessa and Shap Khatun, SHAP, Shap Khatun, are same person. Third name is not here.
Yes, that is for.
Same person. Full stop. Under the next paragraph, under such circumstances, comma, the court is inclined to further examine the matter. Next paragraph, as an interim measure, comma, the petitioner, it is all three names, alias Swenso, is directed to, no, is allowed to go on bail. To the satisfaction of
SPB Borpeta, my lord.
SP Border Borpeta. Next, in the meanwhile, the registry shall procure the trial court records, tribunal's records of FT case number 3 of 2007 from the from the Foreigners Tribunal number 8, Borpeta. Next paragraph, the learned counsel for the petitioner shall inform the court as to, on the next date, as to whether the petitioner has taken bail. Next paragraph, list on September 2024.
September 20.
I think so, but
Pardon me,
all other conditions of.
those will come. This part of the order.
20th September.
20.
Item 29 fixed at 2.
What is the document by which you are connecting yourself to your projected father?
My lord, page number 79, my lord. Jamabandi copy, my lord. It was as exhibit 16 before the learned tribunal.
Page?
79, my lord, vernacular. Vernacular page 82, translated 79.
Yes, where is her name, serial number?
My lord, the father name is at 79, Amir Ali, and her name, my lord, page number.
No, serial number. Give me the serial number.
Serial number 41, my lord, Javeda Khatun. Page 81.
Where is the opinion?
My lord, opinion page number 51, my lord, and there is no discussion about this exhibit, my lord.
Where is the opinion? 51.
Page 51, my lord.
I will examine that. Mhm. You have a legible copy of the that Jamabandi?
My lord, it is there in the LCR, my lord. We have. Original copy, my lord.
The Jamabandi is exhibit number?
16, my lord, 16.
Mhm. Copy. Two thousand seven. It order was 2014. 4/3 2014. Injury order. Proceedings of this. 2007 disability. Process. Father expired 22/3/2007. Kuntu, date will be sir. Nito. Nito. First page, reference we say 2007 of FT case. '98 of reference.
Speed, right?
FT case 98 of the same. FT case 98 of the same. 98 of FT case registered the same. Na tabla D number inter number FT case number 67 of 2007 FT case 12 98. Night to push off. The number was that is it. You look at the 8 number. 8 countries 8 number. You look at 8 number. '98. Repetition of killing is this one. 56. Immediate again. 56. $2,024. 24. 26. 1968. Reference to the 98 of the say. She was 30 years. We are at 37th, he said. Age. Michael. Sim, someone just has been. Document. We have suspect. Standing for what?
169 stating that's an
Kind of police होता है दिया नहीं तो एलवीओ कौन से
Please.
The Jamabandi was exhibit number?
There were two job, 19116,
No. What is the exhibit number of that Jamabandi?
16, my lord.
16.
16.
Please come to that opinion again. Which page?
My lord, the relevant portion, my lord, it starts from page 54, my lord, decision and reason. Page 53, all exhibit has been numbered, my lord. Page 53.
By also keep it. Immediately, is wrong. Non-application of mind. Long down. Non-application of mind.
I'm in detention, my lord. And notice was issued on the IA.
You're in detention.
My lord, 2nd of July.
You filed an IA.
I filed an IA, my lord. Notice, your lordship was pleased to issue a notice on it, my lord. On the last date, my lord.
There was no discussion of the land documents.
Yes, but I have seen it. But the issue, my lord, probably the tribunal has, my lord, the-
May have overlooked or.
Your lordship may kindly see the opinion, my lord.
Hmm.
Opinion at page my lord 55. Why it was not discussed for this reason, my lord? The second pair of page 55, my lord. No, my lord, what my submission is that, my lord, as your lordship knows, this is, my lord, the summary proceeding. Everything may not be discussed in all cases, my lord. Yes, my lord, but my lord, if it is not relevant at all, because the petitioner,
Even that has to be referred, that it is
Yes.
not relevant.
yes, that should have been, my lord, but if your lordship may kindly see the observation, just I'm reading why it was not considered probably for this reason, my lord. Your lordship may kindly see page 55, my lord.
By my orders, because I request these suggestions are given which are not relevant, they are not discussed. That is what I say. But that, if there are complaints that so many judgments are referred, you are not discussed. It may be relevant, it may be irrelevant, but I refer to the judgment and then say it is irrelevant. It may be irrelevant, but absolutely irrelevant. Please discard that. We are not saying that the irrelevant things you must discuss in your opinion.
There is some, my lord, just I'm reading out that portion which actually I was reading. In exhibit 3, her mother name was recorded as, in the second paragraph, my lord. In exhibit 3, her mother name was recorded as Samsul Nessa, aged about 41 years. In 1978, surprisingly, 70, her father was as about 26 years. My lord, this means that her mother is elder than the father by 15 years. A huge difference is found between her father and her mother.
What is wrong? There is a movie.
Yes,
star
my lord,
couple-
that
there's a
I'm
movie star couple of my time.
I'm not saying, my lord, that is wrong, but maybe, my lord, definitely it may be, my lord.
Husband was
As per exhibit 7, death certificate of the father of the opposite party expired on 2007, where also her father's name is recorded as Ahed Ali, Amir Ali, son of Ahed Ali, and not Amir Sheikh, son of Wahed Ali. In all documents, exhibit 1 and 2, these are the two documents, my lord, which relates to, my lord, prior to 1971. Because the best documents are 66 and 71 documents. Then the other documents will come to link that documents, my lord. So if 66 and 71 documents is not related to petitioner or the, my lord, person concerned, then others may not be necessary. That is the, my lord, point. Because
not saying judgment where it said that irrelevant documents need not be discussed in the judgment. I would be so happy.
my lord,
In the division bench judgment, I would be so happy.
my lord, what it is said, my lord, in all documents except exhibit 1 and 2, my lord, your lordship may kindly say, name of the father is recorded as Amir Ali and not Amir Sheikh, a voter and resident of Indian soil prior to 1966. The opposite party have also failed to provide any documents of voter list after 1971, as he is alive, was alive till 22/03/2007, as stated by her and witness.
Take a stand. Then that 1971 is required, and then a link document. Then please tell us why a subsequent, what you call, when there is a link document, why voter list after 71 is required to be on it?
No, my lord, the law says, my lord, that if a person comes prior to 1966 and 70 or prior to 71, his continuous residence in India has to show. After thereafter, as per 66, if he is coming between 66, 71 or prior to 71, my lord. That is the, my lord, section 6A, my lord, 3, 2 and 3. That is there. So that is one issue. My lord, secondly, my lord, if the person was there, suppose the petitioner claiming that, yes, my lord, 6A, because it is relating to, my lord, the 6A of the specific. And if the person, my lord, here, if the projected father was there in 1966 and 71 in the voter list, and he was aliving it up to 2007, why there is not a single documents of that person in between this period? Whether he's the same person or not, the name is different, my lord. The father name is different. So first issue, the tribunal has said, tribunal's opinion is that, my lord, the petitioner first failed to establish that his father or grandfather was there, projected father or grandfather is that person. Then only other documents to come to link himself or herself to that father, mother. Six eight two, mother. Yes.
Who have been already resident in Assam since the dates of the entry.
Six, seven.
He's showing that. Right? Okay.
We'll attempt to dispose of the matter on an early date.
My lord, I may be released because, my lord, just one humble submission, my lord. I was picked up from my home when the matter was pending, my lord, which means that there is no flight risk, my lord. What is the consequence of this order of the Lord?
We'll consider that. You're only trying to see that if we can close the matter
My lord.
at one go.
In the meantime, if I will be released, my lord, I would be grateful, my lord. 56-year-old woman, my lord, picked up from home at the wee hours.
Mr.
I would be
Payam, what do you
grateful.
say? I hear to say. I hear to be.
And during the pendency of this case, my lord, he was picked up.
You know, I
Pendency, pending hypothesis. It has only tailor must mean. LCR purpose.
Mr. Pying, if you want to, any objections you have in the eye?
My lord, I may be given 1 week's time, my lord, if necessary, I'll file an objection, my lord.
Every day, my lord, I just one humble submission. What objection can the state has now?
We don't know.
This case was pending before your lordship. LCR was called for. But my lord, there was no flight trace. She was picked up from her home, my lord.
We had already granted time to the respondents to file their objections.
Last occasion it was given time.
Yes, but therefore we were compelled to ask
Yes.
the respondents if you have any inclination to object.
Only 1 week's, my lord, I'll
One
file an objection. Otherwise,
The date may be fixed, my next week, my lord.
We will have it on 30.
30. Can it be on second, my lord?
It's but more than 1 week, my lord.
You wanted 1 week, we already granted you 30, which is more
In
than
the
1 week.
meantime, there are four holidays for 4 days, my lord, that is. Second or third, my lord?
You know, the logical corollary is deportation, my lord. She is already there at her home. If any occasion arises to deport, my lord, she could have
That will
My
give
lord,
you a
yes.
protection that there shall be no deportation without being to the court.
That my submission is that eventually that will not happen because she belongs to here. I'm just saying that logical corollary is deportation, my lord. I'm not undergoing through any sentence, my lord.
That's right.
Picked up from my home, which proved that there is no flight risk.
I'll get the instruction, my lord, why she has been picked up, because there are
She's been
issues, my
picked
lord.
up because of the opinion.
Yes, my lord, and there are cases, my lord, where they doesn't appear when they are called. For that reason, may also.
There is no instruction to appear before the
So
police.
that's why, my lord, let me get instruction within 1 week. I'll file. If necessary, my lord, we may not file also. Then your lordship may
So
consider.
therefore, we keep it on 30. You get your instructions, we'll take it up on 30.
Yes, I can file, no issue, my lord.
If you want to file, you file. If you have no
Yes, yes, yes.
objections, you tell us, we'll pass orders on 30.
Okay, no issue, my lord. Let it fixed on 30.
Counsels for the parties. In the IA, we learned at State Counsel, Mr. J. Pying, prays for a further week's time to complete his instructions in the matter. Let this IA be listed on 30 August for due consideration of the prayer for release of the from detention of the petitioner. Stop. The writ petition be also listed on the same day along with the trial court reports. Stop. It is made clear that without leave of the court, the petitioner shall not be deported out of the country. In terms of the opinion dated so and so, passed by the Foreigners Tribunal 5th, Dorong, Maldo. List on 30.
May I go to the record for time?
Yes. You're permitted to go through the reports. The report assembly.
Item 9.
May please your lordship, you should in this case, Mr. P.A. Ahmed is out of station. P.A. Ahmed is out of station. So matter will come on next week.
Is out of station.
Yes.
Any objection, Mr. Torman?
No.
People? Matters be listed after a week
Yes.
as it is submitted by
Mr. F. Hassan.
Kia San and the council on behalf of Mr. P. Ahmed that the conducting council is out of station. List this matter after a week on a date to be fixed by the registry.
Obliged.
May please your submission lordship regarding the item number 20, my lord. In this case, lordship, they will consider after receipt the LCR, my lord. 2 times, my lord, it was listed, my lord, but left over, my lord. So kindly.
Can't help it.
Yes.
It's beyond our help. We have to go by the CDM. Once we apply a mind, it takes time.
I have a plan, my lord. In item 21 also, my lord.
We'll have to rise the division
My
bench must break. You tell the court master if it can be accommodated, we can do it.
Only the
Otherwise,
thing
it
is
will-
that when LCR has not come, but it is listed in admission stage. This is a
Item?
fresh case. Item 21.
We want the
will-
LCR to be called.
LCR to be called,
Okay, 21. LCR.
my lord.
See, parties present, let the LCR be.
The interim may kindly be
No, no,
continued.
we don't.
Actually, an error fell through. The private respondent was there who had implemented himself. So what happened in my laptop, that was not there. And that error fell through. My apologies.
Okay. Mr. S. Banik, learned counsel for the applicant,
My lord.
submits that there is a formal defect in the review petition for which he raised to allow him to withdraw the review petition with liberty to approach again. Stop. Mr. V. Rajkwal, and static counsel for the corporation department is present. Full stop. Considering the submission that private respondent who had got himself impeded in the writ proceedings was inadvertently left out in the cost title. The prayer is allowed. The review petition stands dismissed on withdrawn with liberty to approach again.
Public.